shared by a limited number of states. This applies even more to the climate system, which is a resource shared by all states. Cooperation between states is the very foundation of meaningful international efforts with respect to climate change. The duty to cooperate requires sustained and continuous forms of cooperation, of which treaties and their coordinated forms of implementation are a principal expression. While states are not required to conclude treaties, they are required to make good faith efforts to arrive at appropriate forms of collective actions. States must cooperate to achieve concrete emission reduction targets or a methodology for determining contributions of individual states, including with respect to the fulfillment of any collective temperature goal. The Court recognizes that the duty to cooperate leaves states some discretion in determining the means for regulating their GHG emissions. However, this discretion cannot serve as an excuse for states to refrain from cooperating with the required level of due diligence or to present their effort as an entirely voluntary contribution which cannot be subjected to scrutiny. The Court then turns to the relationship between obligations arising from treaties and those arising from customary international law relating to climate change. The Court recalls that the treaty rules and rules of customary international law as norms belonging to two sources of international law retain a separate existence. However, when several norms bear on a single issue, they should, to the extent possible, be interpreted so as to give rise to a single set of compatible obligations. The climate change treaties establish standards that may enable or facilitate the identification and application of the diligence that is due in specific instances. The Court also considers that the obligations arising from the climate change treaties as interpreted herein and state practice in implement them inform the general customary obligations, just as the general customary obligations provide guidance for the interpretation of the climate change treaties. As it is difficult to determine in the abstract the extent to which the climate change treaties and their implementation practice influence the proper understanding of the relevant customary obligations and their application, the Court considers that at the present stage, compliance in full and in good faith by a state with the climate change treaties as interpreted by the Court suggests that this state substantially complies with the general customary duties to prevent significant environmental harm and to cooperate. This does not mean, however, that the customary obligations will be fulfilled simply by states complying with their obligations under the climate change treaties. While the treaties and customary international law inform each other, they establish independent obligations that do not necessarily overlap. It follows from the above that the customary obligation of any state, which is not the party to one or more of the climate change treaties at present, find expression, at least in part, in the general practice of states, which is in accordance with the obligations under the climate change treaties, as interpreted herein. Customary obligations are the same for all states and exist independently regardless of whether a state is a party to the climate change treaties. On this basis, the Court considers that it is possible that a non-party state which cooperate with the community of state parties to the 3 climate change treaties in a way that is equivalent to that of a state party may, in certain circumstances, be considered to fulfill its customary obligations through practice that comports with the required conduct of states under the climate change treaties. However, if a non-party state does not cooperate in such a way, it has a full burden of demonstrating that its policies and practices are in conformity with its customary obligations. The Court then addresses the obligation of states under other environmental treaties. It examines in turn the relevant obligations in the Ozone Layer Convention, the Montreal Protocol, the Biodiversity Convention, and the Desertification Convention, and concludes that the obligations under those treaties are obligations that contribute to ensuring the protection of the climate system as a whole. The Court considers that the environmental treaties it addresses, the climate change treaties, and the relevant obligation under customary international law inform each other. State parties must therefore take their obligations under these environmental treaties into account when implementing the obligations under the climate change treaties and under customary international law, just as they must take their obligations under the climate change treaties and under customary international law into account when implementing their obligations under these environmental treaties. The Court then turns to the obligation of states under UNCLOS. The Court is of the view that anthropogenic GHG emissions may be characterized as pollution of the marine environment within the meaning of UNCLOS. The Court therefore considers that Part 12 of UNCLOS on the protection of the marine environment is applicable in the context of anthropogenic GHG emissions and is thus relevant to answering question A in the present advisory proceedings. On this basis, the Court considers the most relevant obligation of states under UNCLOS to ensure the protection of the climate system. In the view of the Court, the obligation under Article 192 of UNCLOS consists of a positive obligation to take measures to protect and preserve the marine environment and a negative obligation not to degrade it. Standard of due diligence to be applied when complying with the obligation to protect and preserve the marine environment is stringent. The Court also observes that state parties are, under Article 194, Paragraph 1 of UNCLOS, under an obligation to take all necessary measures to reduce and control pollution with the ultimate aim of preventing its occurrence altogether, although they are not required to ensure an immediate cessation of marine pollution caused by anthropogenic GHG emissions. In the view of the Court, it is not necessarily sufficient for state parties to fulfill the obligations under the Framework Convention and the Paris Agreement in order to satisfy the obligation laid down by Article 194, Paragraph 1 of UNCLOS. The Court considers that what constitutes a necessary measure within the meaning of that provision should be assessed according to objective criteria, taking into account the best available science, international rules and standards relating to climate change, and the available means and capabilities of the state concerned, including their different national circumstances. With regard to the obligation to cooperate under Article 197 of UNCLOS, the Court is of the view that it is an obligation of conduct which requires states to act with due diligence. This obligation is of a continuing nature, and it requires state parties, inter alia, to make ongoing efforts to formulate and elaborate rules, standards, and recommended practices and procedures. The adoption of treaties for the protection of climate system, such as the Framework Convention or the Paris Agreement, does not release state parties from this requirement under UNCLOS. The Court further considers that UNCLOS, the climate change treaties, and other relevant environment treaties, as well as the relevant obligations under customary international law, inform each other. The Court then turns to the obligation of states in relation to sea level rise and related issues. With respect to sea level rise and its implications, the Court considers that the provisions of UNCLOS do not require state parties in the context of physical changes resulting from climate change-related sea level rise to update their charts or list of geographical coordinates that show the baselines and outer limit lines of their maritime zones, once they have been duly established in conformity with the Convention. For this reason, state parties to UNCLOS are under no obligation to update such charts or list of geographical coordinates. The Court notes that several participants argued that sea level rise also poses a significant threat to the territorial integrity and thus to the very statehood of small island states. In their view, in the event of the complete loss of a state's territory and the displacement of its population, a strong presumption in favor of continued statehood should apply. In the view of the Court, once a state is established, the disappearance of one of its constituent elements would not necessarily entail the loss of its statehood. The Court then turns to the obligation of states under international human rights law. At the outset, it notes that the environment is the foundation for human life, upon which the health and well-being of both present and future generations depend. The Court thus considers that the protection of the environment is a precondition for the enjoyment of human rights. The Court notes that the adverse effects of climate change, including inter alia, the impact on the health and livelihoods of individuals through events such as sea level rise, drought, desertification, and natural disasters, may significantly impair the enjoyment of certain human rights, including the right to life. The Court considers that conditions resulting from climate change, which are likely to endanger the lives of individuals, may lead them to seek safety in another country or prevent them from returning to their own. In the view of the Court, states have obligations under the principle of non-refoulement, where there are substantial grounds for believing that there is a real risk of irreparable harm to the right to life if individuals are returned to their country of origin. The Court is also of the view that the adverse effects of climate change may significantly impair the effective enjoyment of such human rights as the right to health, the right to an adequate standard of living, which for its part encompasses access to food, water, and housing, the right to privacy, and the rights of women, children, and indigenous peoples. The Court considers that a clean, healthy, and sustainable environment is a precondition for the enjoyment of many human rights, such as the right to life, right to health, and the right to an adequate standard of living, including access to water, food, and housing. The right to a clean, healthy, and sustainable environment results from the interdependence between human rights and the protection of the environment. Consequently, insofar as state parties to human rights treaties are required to guarantee the effective enjoyment of such rights, it is difficult to see how these obligations can be fulfilled without at the same time ensuring the protection of the right to a clean, healthy, and sustainable environment as a human right. The human right to a clean, healthy, and sustainable environment is therefore inherent in the enjoyment of other human rights. The Court thus concludes that under international law, the human right to a clean, healthy, and sustainable environment is essential for the enjoyment of other human rights. With regard to the territorial scope of certain universal human rights treaties that are relevant to answering question A, the Court recalls that it has previously recognized the applicability of human rights treaties when a state exercises jurisdiction outside its territory. In the context of the present advisory proceedings, the Court need not determine the specific circumstances under which a state can be regarded as exercising its jurisdiction outside its own territory, since any such determination depends on the provisions of each treaty. The Court emphasizes in this regard that the scope of human rights treaty law and that of customary law are distinct. Taking into account the adverse effect of climate change on the enjoyment of human rights, the Court considers that the full enjoyment of human rights cannot be ensured without the protection of the climate system and other parts of the environment. In order to guarantee the effective enjoyment of human rights, states must take measures to protect the climate system and other parts of the environment. Under international human rights law, states are required to take necessary measures in this regard. The Court is of the view that international human rights law, the climate change treaties, and other relevant environmental treaties, as well as the relevant obligations under customary international law, inform each other. States must therefore take their obligations under international human rights law into account when implementing the obligations under climate change treaties and other relevant environmental treaties and under customary international law. just as they must take their obligations under the climate change treaties and other relevant environmental treaties and under customary international law into account when implementing their human rights obligations. The Court then turns to question B. As observed earlier, the Court considers that this question concerns the legal consequences arising for states that have breached any of the obligations identified in relation to question A. In respect of question B, the Court's task is to identify in a general manner the legal framework under which the conduct of states can be assessed in order to determine whether a state or group of states is responsible for a breach of its obligations pertaining to the protection of the climate system and the remedies that are available to the injured state or states in case of such a breach. The Court observes that the participants in these proceedings are divided in their views as to whether the general rules on state responsibility apply in the context of climate change, or whether the legal consequences are solely or primarily governed by the climate change treaty framework. With regard to the question of applicability of the rules on state responsibility under question B, the Court notes that those rules do not vary with the nature of the wrongful act in question in the absence of a clearly expressed lex specialis. In order for the lex specialis maxim to apply, there must be some actual inconsistency or else a discernible intention that one provision is to exclude the other. The Court finds that the text, context, and object and purpose of the climate change treaties do not support the proposition that the parties intended to exclude the general rule on state responsibility. In particular, the Court finds no evidence in Articles 8 and 15 or in the procedural mechanisms thereunder of any discernible intention on the part of the parties to Paris Agreement to derogate from the customary international law rules on state responsibility for breaches of those treaty obligations. The Court concludes that responsibility for breaches of obligations under the climate change treaties and in relation to the loss and damage associated with the adverse effects of climate change is to be determined by applying the well-established rules on state responsibility under customary international law. The unprecedented nature and scale of harm resulting from climate change give rise to particular issues in relation to the application of the customary rules on state responsibility. Chief among these issues are questions relating to attribution and causation, which the Court addresses in turn. In considering the alleged difficulties in attributing actions or omissions to a state, the Court emphasizes at the outset that attribution is to be based on criteria determined by international law. In the Court view, the well-established rule of international law that the conduct of any organ of a state must be regarded as an act of that state is applicable in the context of climate change. Failure of a state to take appropriate action to protect the climate system from GHG emissions, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies may constitute an internationally wrongful act which is attributable to that state. The Court also emphasizes that the internationally wrongful act in question is not the emission of GHGs per se, but the breach of conventional and customary obligations identified under question A, pertaining to the protection of the climate system from significant harm resulting from anthropogenic emissions of such gases. In relation to private actors, the Court observes that the obligations it has identified under question A include the obligation of states to regulate the activities of private actors as a matter of due diligence. Therefore, attribution in this context involves attaching to a state its own actions or omissions that constitute a failure to exercise regulatory due diligence. Thus, a state may be responsible where, for example, it has failed to exercise due diligence by not taking the necessary regulatory and legislative measures to limit the quantity of emissions caused by private actors under its jurisdiction. The Court further notes that some participants submitted that it is difficult to invoke responsibility in the context of climate change, given that the wrongful conduct is cumulative in nature, involving different states over a period of time and involving a plurality of states that cause injury to a plurality of injured states. In this respect, the Court observes that while climate change is caused by cumulative GHG emissions, it is scientifically possible to determine each state's total contribution to global emissions, taking into account both historical and current emissions. What constitutes a wrongful act is not the emissions in and of themselves, but actions or omissions causing significant harm to the climate system in breach of a state's international obligations. Furthermore, with respect to the invocation of responsibility for conduct involving a plurality of states that causes injury to a plurality of states, the Court acknowledges that the fact that multiple states have contributed to climate change may indeed increase the difficulty of determining whether and to what extent an individual state's breach of an obligation identified in question A has caused significant harm to the climate system. However, the Court considers that in principle, the rules on state responsibility and the customary international law are capable of addressing a situation in which there exists a plurality of injured or responsible states. Therefore, in the climate change context, the Court considers that each injured state may separately invoke the responsibility of every state which has committed an internationally wrongful act, resulting in damage to the climate system and other parts of the environment. And where several states are responsible for the same internationally wrongful act, the responsibility of each state may be invoked in relation to that act. With regard to causation, the Court begins by observing that causation of damage is not a requirement for the determination of responsibility as such. Causation or causality is a legal concept that plays a role in determining reparation. Since reparation implies the existence of damage, causation must be established between the wrongful act of a state or group of states and particular damage suffered by the injured state, or in the case of a breach of obligation under international human rights law, by the injured individuals. In the court's view, the fact that the damage was the result of concurrent causes is not sufficient to exempt the state from any obligation to make reparation. The existing legal standard for establishing causation, which has been developed in the jurisprudence of the court, is capable of being applied to the establishment of causation between the internationally wrongful act of non-compliance with states' obligations to protect the climate system and the damage suffered by states as a result of such a wrongful act. The court is of the view that the required legal standard of a sufficiently direct and certain causal nexus between alleged wrongful action or omission and the alleged damage is flexible enough to address the challenges arising in respect of the phenomenon of climate change. The court observes that causation involves two distinct elements. First, whether a given climate event or trend can be attributed to anthropogenic climate change, and second, to what extent damage caused by climate change can be attributed to a particular state or group of states. While the second element must be established in concreto in respect of specific claims brought by states in respect of damage, in many cases, the first elements may be addressed by recourse to science. The scientific evidence adduced in these proceedings establishes that significant harm to the climate system has been caused as a result of anthropogenic GHG emissions. The court has observed in the past, I quote, "In cases of alleged environmental damage, particular issues may arise with respect to the existence of damage and causation. The damage may be due to several concurrent causes or the state of science regarding the causal link between the wrongful act and the damage may be uncertain. These are difficulties that must be addressed as and when they arise in light of the facts of the case at hand and the evidence presented to the court." End of quote. In light of the foregoing, the court concludes that while the causal link between the wrongful actions or omissions of a state and the harm arising from climate change is more tenuous than in the case of local sources of pollution, this does not mean that the identification of a causal link is impossible in the climate change context. It merely means that the causal link must be established, in each case, through an in concreto assessment. The court then turns to the question whether the character of certain obligations identified under question A result in any special legal consequences for states. In the present context, the court considers that all states have a common interest in the protection of global environment commons like the atmosphere and the high seas. Consequently, states' obligations pertaining to the protection of the climate system and other parts of the environment from anthropogenic GHG emissions, in particular the obligation to prevent significant transboundary harm under customary international law, are obligations erga omnes. In the treaty context, the court recalls that the Framework Convention and the Paris Agreement acknowledge that climate change is a common concern of humankind, requiring a global response. These treaties seek to protect the essential interests of all states in safeguarding the climate system, which benefits the international community as a whole. As such, the Court considers that the obligations of states under these treaties are obligations erga omnes partes. As a result, all state parties have a legal interest in the protection of the main mitigation obligations set forth in the climate change treaties and may invoke the responsibility of other states for failing to fulfill them. The Court then turns to the legal consequences arising from wrongful acts. The Court cannot, in the context of these advisory proceedings, specify precisely what consequences are entailed by the commission of an internationally wrongful act of breaching obligations to protect the climate system from the anthropogenic GHG emissions, since such consequences, depending on the specific breach in question and on the nature of the particular harm. As a general observation, the Court notes that breaches of state obligations under Question A may give rise to the entire panoply of legal consequences provided for under the law of state responsibility. The Court also notes that breaches of states' obligations do not affect the continued duty of the responsible state to perform the obligation breached. Under customary international law, a state responsible for an internationally wrongful act is under an obligation to cease that act if it is continuing, and if the breached obligation is still in force. In this context, the Court is of the view that the obligation to put an end to the wrongful act may require a state to revoke all administrative, legislative, and other measures that constitute an internationally wrongful act of that state. The duty of cessation may also require states to employ all means at their disposal to reduce their GHG emissions and to take other measures in a manner and to the extent that ensures compliance with their obligations. Additionally, in appropriate circumstances, a responsible state could be required to offer appropriate assurances and the guarantees of non-repetition. Concerning the duty to make reparation, the appropriate nature and quantum of reparations cannot be assessed in the abstract and depends on the circumstances of a particular case. The Court observes that the remedy of restitution, which involves the re-establishment of the situation that existed before the wrongful act was committed, may prove difficult or unfeasible in the case of environmental harm, since such harm is often not easily reversible. Nevertheless, the Court considers that in the circumstances of climate change caused by emissions of GHGs, restitution may take the form of reconstructing damaged or destroyed infrastructure and restoring ecosystems and biodiversity. Whether or not these special forms of restitution are appropriate as reparation for damage suffered by states in relation to climate change is to be determined on a case-by-case basis. Such determinations cannot be made in the abstract. In the event that restitution should prove to be materially impossible, responsible states have an obligation to compensate. The Court considers that it is within the scope of this opinion to consider whether compensation could be owed for significant harm caused by climate change if a sufficiently direct and certain causal nexus can be shown between the wrongful acts of one or more states and the resulting harm. In the climate change context, reparation in the form of compensation may be difficult to calculate, as there is usually a degree of uncertainty with respect to the exact extent of the damage caused. Finally, whether satisfaction is warranted for a violation by a state or states of obligations regarding the emission of GHGs and what form that satisfaction could take will depend on the nature and circumstances of the breach. Before concluding, the Court recalls that it has been suggested that these advisory proceedings are unlike any that have previously come before the Court. At the same time, as the Court concluded earlier, the questions put to it by the General Assembly are legal ones, and the Court, as a court of law, can do no more than address the questions put to it through and within the limits of its judicial function. This is the Court's assigned role in the international legal order. However, the questions posed by the General Assembly represent more than a legal problem. They concern an existential problem of planetary proportions that imperils all forms of life and the very health of our planet. International law, whose authority has been invoked by the General Assembly, has an important but ultimately limited role in resolving this problem. A complete solution to this daunting and self-inflicted problem requires the contribution of all fields of human knowledge, whether law, science, economics, or any other. Above all, a lasting and satisfactory solution requires human will and wisdom at the individual, social, and political levels to change our habits, comforts, and current way of life in order to secure a future for ourselves and those who are yet to come. Through this opinion, the Court participates in the activities of the United Nations and the international community represented in that body with the hope that its conclusions will allow the law to inform and guide social and political action to address the ongoing climate crisis. For these reasons, the Court, 1, unanimously finds that it has jurisdiction to give the advisory opinion requested. 2, unanimously decides to comply with the request for an advisory opinion. 3, as regards question A put by the General Assembly, A, unanimously is of the opinion that the climate change treaties set forth binding obligations for state parties to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions. These obligations include the following. A, state parties to the United Nations Framework Convention on Climate Change have an obligation to adopt measures with a view to contributing to the mitigation of greenhouse gas emissions and adapting to climate change. B, state parties listed in Annex 1 to the United Nations Framework Convention on Climate Change have additional obligations to take the lead in combating climate change by limiting their greenhouse gas emissions and enhancing their greenhouse gas sinks and reservoirs. C, state parties to the United Nations Framework Convention on Climate Change have a duty to cooperate with each other in order to achieve the underlying objective of the Convention. D, state parties to the Kyoto Protocol must comply with the applicable provisions of the protocol. E, state parties to the Paris Agreement have an obligation to act with due diligence in taking measures in accordance with their common but differentiated responsibilities and respective capabilities, capable of making an adequate contribution to achieving the temperature goal set out in the agreement. F, state parties to the Paris Agreement have an obligation to prepare, communicate, and maintain successive and progressive nationally determined contributions which, inter alia, when taken together, are capable of achieving the temperature goal of limiting global warming to 1.5 degrees Celsius above pre-industrial levels. G, state parties to the Paris Agreement have an obligation to pursue measures which are capable of achieving the objectives set out in their successive nationally determined contributions. And H, state parties to the Paris Agreement have obligations of adaptation and cooperation, including through technology and financial transfers, which must be performed in good faith. B, unanimously, is of the opinion that customary international law sets forth obligation for states to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions. These obligations include the following. A, states have a duty to prevent significant harm to the environment by acting with due diligence and to use all means at their disposal to prevent activities carried out within their jurisdiction or control from causing significant harm to the climate system and other parts of the environment in accordance with their common but differentiated responsibilities and respective capabilities. B, states have a duty to cooperate with each other in good faith to prevent significant harm to the climate system and other parts of the environment, which requires sustained and continuous forms of cooperation by states when taking measures to prevent such harm. C, unanimously, is of the opinion that state parties to the Vienna Convention for the Protection of the Ozone Layer and to the Montreal Protocol on substances that deplete ozone layer and its Kigali Amendment, the Convention on Biological Diversity, and the United Nations Convention to combat desertification in those countries experiencing serious drought and or desertification, particularly in Africa, have obligations under these treaties to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions. D, unanimously, is of the opinion that state parties to the United Nations Convention on the Law of the Sea have an obligation to adopt measures to protect and preserve the marine environment, including from the adverse effects of climate change, and to cooperate in good faith. E, unanimously, is of the opinion that states have obligations under international human rights law to respect and ensure the effective enjoyment of human rights by taking necessary measures to protect the climate system and other parts of the environment. 4, as regards question B put by the General Assembly, unanimously is of the opinion that the breach by a state of any obligations identified in response to question A constitute an internationally wrongful act entailing the responsibility of that state, the responsible state is under a continuing duty to perform the obligation breached. The legal consequences resulting from the commission of an internationally wrongful act may include the obligations of A, cessation of the wrongful actions or omissions if they are continuing, B, providing assurances and guarantees of non-repetition of wrongful actions or omissions if circumstances so require, and C, full reparation to injured states in the form of restitution, compensation, and satisfaction, provided that the general conditions of the law of state responsibility are met, including that a sufficiently direct and certain causal nexus can be shown between the wrongful act and injury. I shall now call upon the registrar to read the operative part of the opinion in French.
Par ces motifs.
For these reasons, the Court, 1. Unanimously finds that it has jurisdiction to give the advisory opinion requested. 2. Unanimously decides to comply with the request for an advisory opinion. 3. As regards question A, put by the General Assembly, A. Unanimously is of the opinion that the climate change treaties set forth binding obligations for states parties to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions. These obligations include the following. A. States parties to the United Nations Framework Convention on Climate Change have an obligation to adopt measures with a view to contributing to the mitigation of greenhouse gas emissions and adapting to climate change. B. States parties listed in Annex 1 to the United Nations Framework Convention on Climate Change have additional obligations to take the lead in combating climate change by limiting their greenhouse gas emissions and enhancing their greenhouse gas sinks and reservoirs. C. States parties to the United Nations Framework Convention on Climate Change have a duty to cooperate with each other in order to achieve the underlying objective of the Convention. D. States parties to the Kyoto Protocol must comply with applicable provisions of the Protocol. E. States parties to the Paris Agreement have an obligation to act with due diligence in taking measures in accordance with their common but differentiated responsibilities and respective capabilities, capable of making an adequate contribution to achieving the temperature goal set out in the agreement. F. States parties to the Paris Agreement have an obligation to prepare, communicate and maintain successive and progressive nationally determined contributions which, inter alia, when taken together, are capable of achieving the temperature goal of limiting global warming to 1.5% above pre-industrial levels. G. States parties to the Paris Agreement have an obligation to pursue measures which are capable of achieving the objectives set out in their successive nationally determined contributions. And H. States parties to the Paris Agreement have obligations of adaptation and cooperation, including through technology and financial transfers, which must be performed in good faith. B. Unanimously is of the opinion that customary international law sets forth obligations for states to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions. These obligations include the following. A. States have a duty to prevent significant harm to the environment by acting with due diligence and to use all means at their disposal to prevent activities carried out within their jurisdiction or control from causing significant harm to the climate system and other parts of the environment, in accordance with their common but differentiated responsibilities and respective capabilities. B. States have a duty to cooperate with each other in good faith to prevent significant harm to the climate system and other parts of the environment, which requires sustained and continuous forms of cooperation by states when taking measures to prevent such harm. C. Unanimously is of the opinion that states parties to the Vienna Convention for the Protection of the Ozone Layer and to the Montreal Protocol on Substances that Deplete the Ozone Layer and its Kigali Amendment, the Convention on Biological Diversity, and the United Nations Convention to Combat Desertification in those countries experiencing serious drought and/or desertification, particularly in Africa, have obligations under these treaties to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions. D. Unanimously is of the opinion that states parties to the United Nations Convention on the Law of the Sea have an obligation to adopt measures to protect and preserve the marine environment, including from the adverse effects of climate change, and to cooperate in good faith. E. Unanimously is of the opinion that states have obligations under international human rights law to respect and ensure the effective enjoyment of human rights by taking necessary measures to protect the climate system and other parts of the environment. 4. As regards question B put by the General Assembly, unanimously is of the opinion that a breach by a state of any obligations identified in response to question A constitutes an internationally wrongful act, entailing the responsibility of that state. The responsible state is under a continuing duty to perform the obligation breached. The legal consequences resulting from the commission of an internationally wrongful act may include the obligations of A. Cessation of the wrongful acts or emissions, if they are continuing. B. Providing assurances and guarantees of non-repetition of wrongful acts or emissions, if circumstances so require. And C. Full reparation to injured states in the form of restitution, compensation, and satisfaction, provided that the general conditions of the law of state responsibility are met, including that a sufficiently direct and certain causal nexus can be shown between the wrongful act and injury.
Vice President Sabatini appends a separate opinion to the advisory opinion of the court. Judge Tomka appends a declaration to the advisory opinion of the court. Judges Yusuf, Chue, and Bandari append a separate opinions to the advisory opinion of the court. Judges Bandari and Cleveland append a joint declaration to the advisory opinion of the court. Judge Nolte appends a declaration to the advisory opinion of the court. Judge Charlesworth appends a separate opinion to the advisory opinion of the court. Judges Charlesworth, Brandt, Cleveland, and Arescu append a joint declaration to the advisory opinion of the court. Judge Cleveland appends a declaration to the advisory opinion of the court. Judge Arescu appends a separate opinion to the advisory opinion of the court. Judge Tladi appends a declaration to the advisory opinion of the court. The text of the opinion is available from today in TypeScript. It will also be available almost immediately on the court's internet site. The printed text will be available in the near future. As the court has no other business before it, I declare the sitting closed.
It's okay for you? Oui, c'est bon. Okay. Okay. You want me to speak? I think you're in the feel of the content. One person per car.
Well, I'm logged on. It says wrong password or it's wrong password. Basically, you use it again. Maybe I can figure it out. No, you. Wait, try again with the password. Put a space. No, but you already have the time now. Okay, otherwise I'll do it with you. But do you have the text of the Of course. Okay. Yeah. Yes. Press release summary. A bit.
Ich kann nicht klagen.
Maybe someone hier ik wil heel graag een foto van al die journalisten die klaarstaan. Ja. Molly, get in the picture.
Het work?
Hey, oh, let's go. Thank you.
How many press conferences? I heard we said 4. Okay. But that was before. Maybe people are bored and tired now. So. tête,
Ouais, mais comme ça, je dois pas baisser la tête, c'est d'apparaître en fait.
Tu vois un peu jusque-là?
Ah, ouais, je vois bien, je vois mieux comme ça que comme ça. Mon ventre qui cache. Mais tu vois mon micro?
J'essaie un peu de faire des petites économies de batterie.
Tu vois mon micro ou pas beaucoup?
Là, je vois plus beaucoup. Entre les deux qui sont sur le trépied.
No, Bob isn't smart enough to use those.
Ben ouais, mais c'est nos amis photographes qui ne seront pas contents. Je veux bien essayer. Hein.
On se donne un peu de couleur à l'image.
Parce qu'il est bien vertical. Il est bien vertical? Ça, je ne sais pas voir ici. C'est vertical. Hein.
Là, au milieu entre les deux.
Elle est en train de lui dire congratulations.
Trying to get studio lights on the phone. Ah, they were very popular. Yeah. Bad cat.
Yeah, it's a bad cat. And the Gabia.
But I'm surprised. They get along well?
They got along really well. And he would be, you know, when they bounce, you know, like this. It's like bouncing through the cage stuff. They stick together and all that.
Would you have them have like special cats or kittens or that?
They're separate. They just go along.
We wanted to get a guinea for a temple, a dachshund.
Yeah.
And my sister's veterinarian said no, the temple would just kill people for
They're hunting dogs. Yeah, but the cat.
Well, that's what I was wondering, because we had talked about, like, if they grew up as, like, from a puppy with the guinea pigs, would that, like, use, you know, that smoke and that thing.
And one of those was half cat also hunted. And he would hunt farm alone. Go hunting by himself. And come back next day. But so they were doing never bothered.
No.
But that was in the house. You know? I think it can make a difference.
Yeah. I'm a little afraid that if we got a dachshund and killed our guinea pigs, my wife would be traumatized.
That does sound slightly traumatizing.
And she would never be able to live with her dachshund son. No, I've not, but I keep spending guinea pigs. So I would have a little bit of trouble with that. Oh, the ICD.
So, we've just been asked to wait about another 10 minutes. They're just having a discussion and then they'll come out.
Okay, I'm gonna go grab my phone.
Need help?
It's
Okay, thank you.
Nasty they are.
Hey, look at that.
That's
Oh,
that's Frank. That's Bob.
Frank and Bob, good names.
We had Joe for a while, but then
I like this guy as well.
she had because I guess guinea pigs are really susceptible to stomach issues.
Well, all they do is eat and
She had a stomach issue. I'll leave it at that.
You'll be standing here.
Yeah.
I didn't run away.
No choice.
Always just put the cage on the grass.
Yeah. We've thought about doing that because we have a very tiny patch of grass in our garden, but there are tons of neighborhood cats. And, I have a feeling that they won't be as friendly as.
Well, normally I like to do the pencil a little more gentle with
Immer Angst, irgendwas zu verpassen. Das ist der Job. Der Job, der macht immer
Wie lange warst du schon?
insgesamt dann 2020. Musikproduktion.
Ja.
Aber ja, jetzt hier in Brüssel bin ich seit Oktober. Und bin aber auch in Finnland.
Aber wo ist denn heute arbeitest du dann mit
President General. You know who's gonna make Bob. Or excuse me, Alan.
You mean pet?
Yeah. Bob, Alan.
Ist bei der aktuellen Weltlage auch krass belastet.
No, I think Bob will leave with the president, huh?
like they're right out of Chicago or something.
Yeah.
Felix.
Wat fijn is het. Ja, positief. Still reason what this like.
I think there's a lot of things that will be helpful.
You know, if I wanted, I'll try to be honest, if I wanted to practice law anywhere, it would have been in the UK, so that I could have all that pomp and whatnot of wearing the silly, funny wigs.
I understand. So, but maybe you could also get a bit boring.
Yeah, I suppose like after the second time for it,
Yeah.
you're like, oh, I got to put all that crap on. Yeah, yeah, a hotspot.
Just I cable it because you get interference.
Okay. I guess that makes sense because it's not using the same descendant to.
Ja, dat doe ik zo maar even al. Dus die daar staat, die staat ook naar beneden. Dat werd maar niet getrokken.
Ja.
Ja, dat willen ze nou eenmaal zo. Ze mogen er ook niet te lang slopen.
No, I only noticed
In
one.
elkaar speelt, weet je wel. Dat is ook wel.
Only for him? I don't know.
Ik doe de andere kant. En Peter wil de bovenkant.
Okay. Yeah.
Oh,
That
right.
makes sense.
Okay.
Yeah, I use my phone as a hotspot, and it just burns the battery. My phone gets super hot.
Ja, nou, we gaan maar doen. Wil jij hem achter mij oké? Zit die man lekker? Dat is goed, dat is goed.
Oh, yeah, but maybe we can
Cameraman.
Sorry.
Okay, we're going down.
Can you go down with
Yes. If you all could maybe maybe everyone could stand. Minister Regan Vanu, Mr. Kiloway maybe over here, and Michelle next to us. Maybe on this Margareta and Julian and Coral. Are we ready? Okay. Okay, we're starting. Thank you for joining us today. I'm Preeti Singh, and I'll be the moderator for this press conference, which is hosted by the Government of Vanuatu. The International Court of Justice has just issued its advisory opinion, clarifying the obligations of states in respect of climate change. The Government of Vanuatu, with allies, led the campaign at the state level to obtain this advisory opinion. Speaking today will be Ralph Regan-Vanu, the Minister of Climate Change Adaptation, Meteorology and Geohazards, Energy, Environment and Disaster Management for the Republic of Vanuatu. Also, Mr. Elon Kiloway, Acting Director General of the Melanesian Spearhead Group, and Vishal Prasad, Director of Pacific Islands Students Fighting Climate Change. We will have time for questions following the speaker's remarks. We do have additional respondents who will be available for the Q&A, including Margareta Weverenke Singh, who is legal counsel for Vanuatu's ICJ case, an international lawyer at Blue Ocean Law, Mr. Julian Agawan, co-founder of Blue Ocean Law, and Ms. Coral Pasisi, who is Director of Climate Change and Sustainability with the Pacific Community, called SPC. And with that, I will ask Mr. Ralph Regan-Vanu to make some remarks.
First of all, I just want to say thank you so much to the media for your interest and coverage of this critical case. It's been really important in building momentum and getting the world to expect what has come out today. So today it's been a landmark milestone for climate action, the discourse on climate change, and it's very important course correction in this critically important time. For the first time in history, the ICJ has spoken directly about the biggest threat facing humanity, which is climate change. And I want to note that the decision was unanimous. And it reminds me of 29th of March last year, when the General Assembly referred the question here, and it was also unanimous, which is the first time in the history of referrals to the ICJ. And I don't know to what extent this unanimity of the court is historic as well, but it really points to the critical nature of this issue and also the consensus of most people in the world that we need to really address it as a matter of urgency. I want to also reflect on the importance of the science. We heard from this advisory opinion that climate science is the heart of climate law and the compass for climate justice. The evidence is clear, and we can see it everywhere, that climate change is affecting everybody all over the world. For the first time ever, this past decade includes the 10 hottest years on record, and last year being the hottest ever. And this year we're seeing it all again. And this number will continue to intensify as climate change intensifies. So today's ruling is a landmark moment, and it's confirmed what vulnerable nations have been saying and we've known for so long, that states do have legal obligations to act on climate change, and these obligations are grounded in international law, they're grounded in human rights law, and they're grounded in the duty to protect our environment, which we heard the court refer to so much. And these aren't aspirational ideas, as some would have it. The court has just confirmed they are binding duties. And the advisory opinion has clarified the legal consequences for states which fail to discharge these obligations. So we're approaching COP. We're a decade on now from the Paris Agreement. And it's very important now as the world goes forward that we make sure our actions align with what was decided or what came out today from the court. Today's ruling, I'm sure, will also inspire new cases where victims around the world in a legal sense realize that they can claim their rights and seek accountability. I know you're all wondering what's next. When we're now going to take the ICJ ruling, this one back to the United Nations General Assembly and pursue a resolution to support the implementation of the decision at the UNGA. The implementation of this decision, we hope, will set a new status quo and provide the structural changes needed to give our current and future generations hope for a healthy planet and a sustainable future. So let this be the moment when we see a change and the world turns its face towards climate justice, and this legal clarity provides us with the moral courage to take this forward. Thank you.
Thank you. Next, we will hear from Mr. Kiloe with the Melanesian Spearhead Group. Please go ahead.
Thank you very much. I'd like to begin by echoing the sentiments expressed by the Minister in thanking members of the media for the interest we've expressed in this case. The Melanesian Spearhead Group had the rare opportunity last year in joining Vanuatu and the Pacific Islands students in opening the ICJ proceedings on the 2nd of December here. In our submission, we've asserted that human rights guarantees all peoples the ability to freely determine and choose their economic, social, and cultural developments. However, in the Pacific, this is virtually impossible in light of the impacts of climate change in our countries and also our communities. The Melanesian Spearhead Group, which consists of Fiji, Papua New Guinea, Solomon Islands, Vanuatu, and the Front and Socialist National Liberation of New Caledonia, we are already losing our natural resources that are critical to our cultural and physical subsistence. Our people have suffered forced relocations from our traditional territories. Our political systems are breaking down as our economy is ground to ashes. We have already lost much of what defines us as Pacific Islanders, and climate change has only gotten started. So where do we find hope? For the Melanesian Spearhead Group Secretariat, we look to Vanuatu and the Pacific Island students who have led the charge for climate justice. Their initiative exemplify the power of leadership in addressing this global crisis. Having the ICJ, the highest court in the world, to address the climate crisis is an idea that began from a spark of hope from our Pacific youth. They led the push for this case because they cannot afford to wait on the promises and the pledges of our leaders. This crisis is here and not something that can be pushed onto our next generations or the ones after that. The future generations are saying quite clearly that the world needs action now. The advisory opinion is not the end of the ICJ process. Instead, it is only the beginning. The opinion confirmed that polluter states have breached the rights of Vanuatu and other climate vulnerable states. The ICJ also confirmed that climate justice is inseparable from human rights and environmental protection. It affirms that nations cannot turn their backs on those suffering the consequences of harm caused by others and ongoing inaction. The advisory opinion will be an essential tool that we in the Global South will use at the next meeting of the United Nations General Assembly, the UN's Climate Change and Biodiversity Conferences, and everywhere to advocate for climate justice so that our generations can enjoy the future we want. Thank you very much.
Thank you, Mr. Kilaway. Lastly, we will hear from Vishal Prasad. Please go ahead, Vishal.
Thank you, everyone. Pulavinaka. Indeed, it's a truly historic day for climate justice. 6 years ago, young people from the Pacific decided to take climate change to the world's highest court, and today the ICJ has responded. In no uncertain terms, it has told the world that climate impunity is no longer allowed, and that those who have caused the greatest harm are required to provide remedy to people most affected by climate change. By affirming the science, the ICJ has mandated countries to urgently phase out fossil fuels because they are no longer tenable. For small island states, communities in the Pacific, and for young people, and for future generations, this opinion is a lifeline and an opportunity to protect all that we hold dear and all that we love. This ruling is also a testament to the resolve of people everywhere. Those at the front lines who chose not to allow the decisions of a minority of countries to dictate the future of the global majority. Instead, this advisory opinion today provides us a foundation to build a better, sustainable, and more equitable future for all of us. I am convinced now that there is hope and that we can return to our families and communities back home in the Pacific saying the same. Today is historic for climate justice, and we are one step closer to realizing this. Thank you.
Thank you, Vishal. Now we will take questions from here at the Peace Palace and some from the Zoom chat. Please raise your hand if you have a question and state your name, media outlet, and to whom you are asking the question. Go ahead.
Cynthia Van from Reuters. I wanted to address my question to maybe Ralph and Margaretha. Can you explain how this ruling might be used in further climate litigation from states against polluting states? Because we've heard that they have an extra obligation. Can you kind of draw out how they would use it, and do you have plans to seek other cases?
Yes, the court in this ruling has provided the full framework for holding states to account for pollutions that are internationally wrongful, unlawful, and that cause injury to other states, and even when no injury is caused yet. But if injury is caused, then states who suffer that injury can essentially claim reparations from the state that has caused the harm. The court has made that crystal clear, and a whole range of defenses that could be raised in such cases by the polluting states have already been dismissed by the court. So it really strengthens the legal basis for such claims going forward. Even though of course we hope that it's not going to be necessary, but in case it is.
And can they file those claims here or in other courts?
That depends on the whole range of questions, but potentially here, depending on the states in question.
Great. Do we have another question?
Bob Berwin with Inside Climate News. Can someone speak to the section that addresses reparations and what that specifically might mean, especially in the context of next steps at the UN? Thank you.
Go ahead, Margareta.
Just so everyone can hear, the question is about reparations.
Please stand in the middle in front of the microphone.
So here, the court has provided critical guidance that is very helpful to those seeking climate justice. The court has made it clear that the law of state responsibility applies to losses and damages from climate change. And this is important because there was an argument that liability and compensation had been excluded or made impossible because of a decision that was taken in 2015. It was attached to the Paris Agreement, where a paragraph said that there would be no, the Article 8 of the Paris Agreement provided no basis for liability or compensation. And the court made it clear that when there is injury or loss and damage, the usual law on state responsibility applies, And that law provides that when a state commits a wrongful act, it is under a legal obligation to make full reparations for the damages caused. And then the court also addressed a few possible counter-arguments that could be made, such as the damages too diffuse. There are too many states that are responsible. There are too many states that are injured, and therefore it's impossible to win, let's say, a claim on reparations. And the court made it clear that these are not necessarily obstacles, and the usual rules apply. So every case has to be assessed based on the facts that are applicable. But the court noted that the science has evolved so much that it's actually possible to establish these causal links. And so any case would need to be tested, but the prospects look very favorable.
Go ahead.
Hi there, Richard Carter from AFP. For you, Minister, if I may, as you said, it's a very wide-ranging opinion delivered by the court today. What for you has been the most significant part of the ruling? And for Vishal, if I may as well, it's been a six-year journey ending in this historic day. So how do you feel?
So yeah, I mean, I was very. I was. It was unexpectedly good for me that the advisory opinion. I didn't expect it to be this good, and it did go above and beyond. Like it talked about the rights of states to exist regardless of sea level rise, and that's a very important issue for the Pacific. And for the ICJ to give an opinion, that was fantastic. Directly addressed fossil fuels and states that give licenses, give exploration licenses were mentioned, subsidize, produce. It's an internationally wrongful act to do so, and that they are under international law. They are being. It is a breach of their duties. So those kind of specifics was something that, for me, went above and beyond what I was expecting, and I'm very grateful for the court to make those pronouncements.
I think I'm completely overjoyed with what the outcome of the opinion has been, and we're still trying to digest it. As someone said, we all might be in a state of shock at the moment with what the court has given us, and I think it sends a strong message for all of us and to young people everywhere that there is still hope, and there is a chance, and there's a reason for us to keep fighting, because as we said, that this advisory opinion is a tool for climate justice, and boy, has the ICJ given us a strong tool to carry on the fight for climate justice, and so we're very glad.
Thank you. I'm taking a question from our Zoom chat, either for Margareta or Minister Regenvanu. This is from John Anger at Bloomberg. The U.S., the world's largest historical emitter, doesn't recognize the ICJ's legal authority. So what impact will this ruling have on the U.S.?
Yeah, I would correct that statement. The court has two judicial functions, an advisory function and a function to settle disputes between states. And there is a possibility for states to accept the jurisdiction of the court in contentious cases as compulsory, which the US has not done. But for the advisory function of the court, all UN member states necessarily, by virtue of being UN member states, recognize the jurisdiction of the court fully. In this case, the advice was requested by the UN General Assembly. The resolution was adopted by consensus. The US didn't even vote against this resolution or didn't even abstain. It actually joined the consensus. And so it is the UNGA, including the US, that has requested the opinion. The opinion is now delivered to the UNGA, and the US, as long as it's part of the UN, of the United Nations, is also supposed to follow this advice. So it is as much bound by this advice as other states are.
Thank you. Go ahead.
My name is Laura Kostan for ARD German Television. A question for Mr. Prasad. How hopeful are you that this advisory opinion might be one of the first steps of maybe a paradigm shift of more legal implications to actually bring more climate justice into the multilateral system?
Well, I think I'm very hopeful that this advisory opinion will bring the transformational shift that we've been calling for. I think this journey started and the transformational shift started when the proceedings at the ICJ started, with many of the global south countries, many that have not been at the ICJ before, who have not presented themselves or been part of the ICJ proceedings, have participated in such a manner. They came out in numbers, and this was a complete shift into what we normally see, and I think that shift has begun in the written proceedings, the oral proceedings, with a number of indigenous voices, arguments, women, young people speaking, and the diversity of arguments. And this advisory opinion acknowledges all of that in its strength, and I think it sets the foundation for a transformational shift beyond into multilaterals, in the courtrooms, and at national and regional level. So again, a big reason to be hopeful.
Could this advisory opinion have been any better?
I mean, we were talking about this, that everything we asked for, everything we had hoped, seemingly is in this advisory. Of course, we'd have to go forward and read the whole opinion, which is going to be many, many pages long. But we're very, very grateful and very happy with what the outcome is today.
Go ahead.
Hopefully not. Hopefully the confirmation of the law as it applies is enough for those who would owe reparations to actually start providing them, because these same states, the big historical polluters, essentially have been arguing that they are under no obligation to make reparations. They provide it on a voluntary basis, if and when they please, and as much or as little as they please. And so the court has made it crystal clear that if you do not provide reparations that are, I think it's implicit, proportionate to your contributions, then you can be held to account, and many states may prefer to actually voluntarily then scale up the contributions that they're making, for example, to the loss and damage fund, than actually to be confronted with litigation.
Great. I will take another question from Zoom. This is for Margareta from Ben German with Axios. The ruling gets into the NDCs under Paris at some length. The common wisdom has been that NDCs under Paris are non-binding statements of targets and aspirations. My question, does this ruling open the door for legal challenges that rest on failure by countries to implement their NDCs?
Absolutely. The court made it very clear that failure to implement an NDC would amount to a lack of good faith and a violation of the state's obligations. And it's not only that, the content of the NDC also has to be consistent with the goals of the Paris Agreement, including the 1.5 temperature goal. And so if that is not the case, and of course that raises some complexities, but in some cases it may be clear that it's not aligned with 1.5 of its common but differentiated responsibilities, and then indeed it's clear that there is a breach of obligation and a litigation could be pursued.
Go ahead.
Are there any consequences Vanuatu can draw right away from this opinion?
No, not right now. We'll have to have a look at it first and discuss. And
Great. I'll take another question for the Zoom chat. This is for Margareta from Panthea Lee at The Nation. Intergenerational equity has long been treated as a soft law principle. Do you think the ICJ's affirmation of obligations to future generations moves it closer to becoming a binding norm in international law? What is new here?
Yes, the court in fact explicitly confirmed that intergenerational equity is a binding principle, and it is applicable to the conduct that has caused climate change. It specified that intergenerational equity informs the interpretation and the application of the other treaty obligations. So take, for example, human rights. The right to life must be interpreted in light of intergenerational equity. The same with all the climate obligations, with all of the other obligations on the law of the sea and so forth that the court specified. So the implications are really far-reaching.
Any questions here? Yes.
Hi, Meike Leyers for Dutch public broadcaster NOS. I do have a question for Minister Regenbanu. As everyone knows, climate change is happening right now. It's unfolding as we speak, and there is a pressure, a time pressure. Now, are you concerned that now that there may be a lot of new climate cases happening all over the world, that it's still going to take quite a long time before those actions will actually be taken? And do you have any plans to avoid that long period of time from happening and get action quicker?
Well, I mean, this initiative was part of that, trying to get action quicker, because we've been in the UNFCCC process for 30 years. We are we're pulling all international levers possible. We were part of the COSIS group that went to the ITLOS and got that advisory opinion. We made a submission as part of the Inter-American Court of Human Rights. We are pushing for the law, a crime of ecocide, to recognise in the ICC. We're part of the Fossil Fuel Non-Proliferation Treaty, pushing to get member countries to that. So we're trying everything possible at international level to speed up action. This is, I think today has been a very concrete contribution to that, speeding up of action.
Great. I have another question from the chat from Margareta. This is from Marlise Simons at the New York Times. What was the key contribution from the court's advisory opinion, would you say? Or what was missing?
Well, the key contribution is really twofold. That this whole spectrum of obligations applies to the conduct that has caused climate change. And when we look at conduct, we shouldn't only look at states' emissions, but also at what they fail to do, regulating private actors or providing fossil fuel subsidies, providing finance or not doing so, or not providing enough. And so that conduct needs to be assessed in light of these obligations. And then if you do that, many states will actually fall short of these obligations. And once that is established, the law of state responsibility applies. And that is just you can say, the foundation of international law itself. It means that when you commit a wrongful act, you violate your obligations, you can be held responsible. You need to stop doing that unlawful thing, or failing to do what you need to do, and you need to make reparations for the injury that you have caused with that wrongful conduct. And so the implications are really tremendous. If you think about essentially the polluter pays principle, which you can say is a simple way of summarizing all of this, it means that the era where polluters can freely pollute and can argue that their climate policies are a matter of discretion, they're free to decide on their climate policies, that era is really over. We have entered an era of accountability where states can be held to account for their current emissions if they're excessive, but also for what they have failed to do in the past. So the Kyoto Protocol was mentioned as an example, that if states can still be held to account for failing to meet their obligations under the Kyoto Protocol. And it's just an illustration of how we can also look back and ensure that the harm that has already been inflicted can be repaired.
Okay, thank you. We have one more question on chat. Is there any last question from the audience here? No, okay. So this is the last question. It's for Minister Ralph. It's a question from Sanjeshni Kumar from the Pacific Islands News Association. What message would you send to major emitters following this opinion?
It's the same message the Pacific has been preaching loudly for so long, that it's you've got to do what you agreed to do at Paris, for example. You can't just make these commitments and then just walk away from them. You are legally accountable, and so our message would be, I mean, the court mentioned a number of times good faith, talked about international cooperation, the duty to cooperate internationally. So we continue to call upon all states to follow the science, follow what the IPCC was mentioned as the foundation for the science that the ICJ based its opinion on, which tells us we need to rapidly reduce emissions to keep within the targets of 1.5 and less. and we just hope that this will give more impetus to our call that we've been making for so many years, and we will be seeking all avenues to try and get this decision, this advisory opinion, implemented into policy and decision at the highest levels.
Great, thank you. So please be in touch with the Vanuatu team if you have any follow-ups. We will be issuing a media statement and later tonight a legal summary. And with that, I'd like to thank our speakers and conclude the briefing. Thank you all for attending.
We have a couple of minutes maybe from the first panel. Would that work?
You said one of the most what does that mean? Will there now be many more legal cases filed by Vanuatu?
No, hopefully not. Hopefully.
One shaped not just by power, but also by principle. We welcome the Court's opinion and its recognition of key legal principles that AOSIS and our member states have consistently advanced. The opinion reflects a clear, unanimous, and progressive understanding of the international legal framework that governs the global response to the climate crisis. And we want to focus on 4 areas that are different than what our colleagues spoke to. So first, and crucially, the Court found that the 1.5 degree temperature limit is a scientifically based consensus under the Paris Agreement and is now a legally binding target. This is a revolutionary development. For SIDS, holding the line at 1.5 degrees is not negotiable. It is essential for the survival of our people. Second, we are especially encouraged by the Court's affirmation of the duty of international cooperation as part of customary international law. For SIDS, climate change is not a distant threat. It is a present and intensifying challenge. Addressing it requires more than voluntary action. It demands collective, sustained, and legally mandated cooperation. The duty to cooperate is foundational to climate justice and to international environmental law. Third, AOSIS strongly supports the Court's finding on the stability of maritime baselines and entitlements, even in the face of sea level rise. AOSIS has long asserted that the law of the sea must provide certainty and security for low-lying island states. The Court's recognition that climate change must not undermine the rights of SIDS under UNCLOS is a crucial affirmation for legal stability. And fourth and finally, we echo the Court's approach to the continuity of statehood. AOSIS has consistently maintained that the loss of habitable territory cannot and must not extinguish the statehood, sovereignty, or international rights of states. The Court's opinion reinforces that the legal existence and identity of states persist, even amid changes to territory.
And we frequently hear small island developing states described as the moral voice in international relations. Today, however, we have demonstrated that our engagement transcends moral imperatives. This is fundamentally about legal obligations established rights, and the binding force of international law. The ICJ has shown the path forward. This advisory opinion must now inform and strengthen the global response to climate change, including in negotiations under the UNFCCC and the Paris Agreement, and guide the interpretation of international obligations across all forums. AOSIS expresses deep gratitude to all states that supported the General Assembly resolution and to the legal experts and youth, especially those from the Pacific and Vanuatu who helped make this moment possible. This is proof that small states can shape international law and that justice and principle can prevail. But this ruling is only the beginning. Now states must walk the path the courts has laid out. No more delay, no more ambiguity, action must follow, grounded in law, backed by finance, and driven by justice. In our increasingly volatile world, international law provides precisely what we need. Small island developing states require certainty, predictability, resilience, and future-proofing. AOSIS will carry this ruling into every negotiation, every courtroom, every call for justice. For small islands, this is not just about climate, it is about our future, and we will never stop defending it. Thank you.